Right.
Good morning, Judge Simpson. Attorney Carl Jordan, P 57226, appearing on behalf of Ms. Deanna Seaborn, and Ms. Seaborn is present, Your Honor.
All right. Go ahead.
First of all, Your Honor, I apologize for running late.
All
I know that the time was changed, but I was in another court. No excuses. I apologize.
right. Very good.
Your Honor, with respect to Ms. Seaborn, she did plead no. I did go over the PSI with her. There are no additions, deletions, or corrections made. I would just like to address what I believe would be an appropriate sentence.
Yeah, go ahead.
They are asking, Your Honor, for 29 days, 365, and I believe that they're asking for that to be held in abeyance, but that you serve 29 days. I don't believe, Your Honor, that that would be appropriate. And I'm jumping straight to that aspect because, first of all, Ms. Seaborn is extremely remorseful for what happened. She did not give a statement because she was allowed to plead no contest due to civil liability. But make no mistake about it, she took her job seriously. She did not want to harm anyone, certainly not a special needs child. This is by no means an excuse, Your Honor. But when I asked her, why she may have done what she did, because she has no prior record, she said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that that is an excuse, Your Honor, especially when you consider it as a child, and especially when you consider it as a special needs child. But I do want the court to know that had that not occurred, she would not be before any criminal judge, and I do not believe that she will be in front of any criminal judge in the future. She will complete probation successfully and go on and live her life. There have been some consequences. She did lose her job that she had as a result of these charges. So now she is doing DoorDash in addition to taking care of her sister. But again, she's sorry, she's remorseful, and she wants the court to know she has learned her lesson. Thank you, Your Honor.
Anything you want to say before I impose sentence?
No.
Well, I'm going to say this, counsel, and I appreciate the elocution. However, when I look at the circumstances of this case, this is a special needs child. Certainly, some things are going to occur. Certainly, it can maybe raise one's ire, but to do these things is, in my estimation, inexcusable. I mean, these parents, through each stage of a process on a day-to-day basis, entrust their child to these folks. And quite frankly, when you violate that trust, it's inexcusable in a lot of ways, in my mind. I mean, in particular, that this is a child that really cannot defend themselves if they even comprehend exactly what's happening to them. I mean, which just has to be sort of the worst thing. Was there a victim's impact statement? I was expecting that there might.
I did not receive one, and I do not see the victims present.
All right. It is a sentence of the court. Place you on probation for a period of 60 months. You're to pay $655 fines and court costs, $1,800 probation oversight fees. When can that be paid?
You said 1,800, Your Honor?
Yes, that's what I have. Yeah, it's 60 months.
Your Honor, she realistically says that she can pay $150 a month.
Okay. $150 a month. That will begin in January 2026.
Thank you, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. Will be subject to random testing as requested by probation. You are to complete the anger habits program. You're to complete 50 hours of community service. There's to be no contact with Elizabeth, Peter, or Eli Lorensky, if I'm pronouncing that last name correctly, that is directly or indirectly. You are not to be working with and or around any minor children. There's to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. And let me just say this. You know, like I said, these parents entrust you, and you know, at no point, other than for the purposes of safety or other legitimate reasons, do you have the right to place your hands on that child? That's the only basis of you're trained, should have been trained, and I think you were, as to how to deal with these circumstances and these situations. You're having a bad day, losing control, and doing this kind of thing is never an option. And I understand counsel isn't saying it is in its use, but it's not an option for you when you get into that uh, role and in that circumstance. And so what I'm going to do is I'm going to order 365 days in jail. Give you credit for the 1 day that you serve. You will be remanded to serve an additional 29 days, and then the balance will be suspended. Defendant is remanded.
Your Honor, I spoke to my client about this, and she said, could she have time to get her affairs in order? And I said, well, really, what affairs do you need to get in order? I mean, the president of the United States could get his affairs in order probably quickly. And she said, I do have a daughter who's 14, and I wasn't expecting to have to serve any time because it wasn't part of the negotiations. May she have at least a few days so that she can arrange for a 14-year-old to go somewhere? She does have a sister, but her sister is the person that she takes care of. Her sister was shot. She's in the courtroom. So she truly does need to make provisions with respect to her daughter. And she understands if she,
At the moment this was happening with the child, was that child permitted to make any arrangements for their care? Probably not.
of course not.
I will not pay her the same courtesy. Defendant remanded, she'll go today.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Lucille Slater.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater, who is approaching. Please state your name for the record, ma'am.
Lucille Slater.
Thank you.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Ms. Slater. We only have one brief correction, and that is on page 2 under the summary. It states that she pled no contest to this charge on the date of her pretrial hearing on the 17th. That is correct that it occurred on the 17th, but that was the date of her final settlement conference. That is the only correction we have, Your Honor. And as to the recommendation, I do believe it to be fair recommendation, and I would ultimately ask the court to adopt it. Ms. Slater presents to the court, she's 76 years old with no prior convictions of any kind. This is quite literally her first rodeo in this situation. She has, throughout my representation of her, taken this matter very seriously and has, to me, shown a lot of remorse for her actions on that day. She, prior to this incident, she had worked at this position for almost 7 years, and to my knowledge, had no other prior incidents of this kind. This is her first interaction with the criminal justice system. She has expressed much remorse to me. To my understanding, she has complied with her bond to the T and has appeared in person for all her court dates. I would ask that the court adopt this recommendation.
Ma'am, is there anything you want to say before the court imposes sentence?
No.
Your Honor, I'm sorry to interrupt.
Yes, I will get to that in just a moment. I was aware.
No, Your Honor.
All right. You guys are going to need to have a seat here. All right. Please, somebody. All right. I understand there's a victim's impact statement.
Yes, Your Honor. The minor child's mother and father is Julie and Ryan Franks. They are present.
Julie and Ryan.
Julie and Ryan.
Got it. All right. Hello.
Hi, Your Honor.
Could you state your names for the record?
Yeah, Julie Franks.
Ryan Franks.
All right, thank you. And I'll need you to take your hands out of your pockets if you would. Thank you. All right, I think we're all set now. Go ahead.
Thank you, Your Honor. Thank you for giving us the opportunity to speak today. We are here as the parents of a 7-year-old little girl who was physically grabbed and yelled at by Ms. Slater at school. a place where she should have felt completely safe. That day changed our daughter. Since then, Natalie has struggled with anxiety and fear. She often asks questions no child should have to ask. Things like, why did that happen? And will that happen to me again? It has been incredibly painful as her parents to watch her confidence fade and to see her question the trust she used to have in the adults around her. We spent months trying to rebuild her sense of safety through reassurance, through love, but this incident left a mark. It's something she carries and will carry with her forever, and something we, as her parents, will never forget. What's been equally hard is seeing how little remorse Miss Slater has shown. When police reached out to get her statement, she hung up on them and blocked their number. That forced us to move forward and press charges. When officers went to her home, she refused to answer the door, even though they could clearly hear people inside. Those actions speak volumes. They show a complete lack of accountability, of remorse, and of understanding of the harm she caused. We truly believe that if given the opportunity, she could have hurt another child. We understand that everyone makes mistakes, but when an adult's action causes emotional and physical harm to a child, that can't be taken lightly. Our greatest hope is that the court ensures that this individual is not in a position to work or be responsible for children. No family should have to go through what ours has. We're speaking today, not just for our daughter, but for every child who deserves to feel safe and protected at school. That's all any parents want, to know that their child is safe when they walk through those doors. Thank you, Your Honor, for listening to our story and for considering the impact this has had on our daughter and our family.
Thank you for coming down. All right. All right. Is there anything she wants to say now?
Just very briefly, Your Honor, I do want to mention Ms. Slater has taken accountability and has expressed remorse in this matter. Of course, to me, and of course, by entering a plea in this case. She takes accountability for what actions did occur, and she is remorseful. I can say that through my many discussions with Ms. Slater, and she does take accountability for what did occur. And I do believe she is remorseful, and her choice not to give a voluntary statement to the police, I believe, was based on the advice she had received through counsel and other means. That being said, she is remorseful for her actions and has taken accountability.
Anything you want to say?
No, Your Honor.
Okay. So I get the notion that prior to anything happening, and I can understand why it might confuse the Franks, or they're not appreciating that she may have been told by she was a union employee or through lawyers not to say anything, not to have contact. So I get that, and that might be, one might expect as a parent that somebody might act a little bit differently. But I get why somebody would act. I am, however, a bit concerned that as we get here today, as we are here today, that there's this little girl and something happened to her. And standing there in her stead are her parents who have taken their time to come down to let the court know basically the effect that this has had on their child, which, I guess, spoken like true parents, but also moms will do this. They don't express necessarily the impact that it's had on them, but they talk about what's happened to their child. And I did something different because I was told prior to this hearing and in reading the report that there wasn't a sense of remorse for what had happened. Even if done accidental, even if done out of a misapplied sense of how to have this child saved. They were people saying, well, she's not really showing remorse. She didn't really care what happened to this child. And where I did something different because my staff here knows how I typically will handle these situations when I have impact statements. You would have sat down. They would have spoken to me, and then you would come back up. But I would not have addressed you prior to Frank speaking. Do it that way pretty much every time. I did it differently for a reason today. Because I was at least going to give you maybe 2 opportunities to look that little girl's parents in the eyes. And whether or not you meant to do what you did, just to tell them you're sorry. Because that's their baby girl. And I gave you those 2 opportunities the first time. Nothing. You sat down. You heard mom speak. Came back up. Asked you again. And nothing. I don't know how you do that. It puts into perspective for this court what happened that day. Because I sat there and I thought to myself, well, here's somebody who works for the school. Things can get out of control. They can do this, but you know, it's just like I told the person before you. I'm not sure that you've got a right, except for the purpose for safety reasons or other necessary reasons, to put your hands on somebody else's child. You can't do it. And then, if you lose your mind for a minute, for whatever the reason, and you do, then quite frankly, you take responsibility for it. You say, I shouldn't have done it. And if you can't apologize to the little person, you apologize to her parents. So at least her parents can go and say, hey, look, she apologized. This is her version of it. She didn't mean it. And they can sort of move forward with that lesson that they're entrusted to teach their child. But you can't even do that.
If I may, Your Honor, my client and I have had to discuss the no contact order multiple times, partially for that reason. I have had to remind her that she is under a court order not to reach out to the Franks and apologize, not just the minor child, but as the adults. And pursuant to that court order, she has not had any contact with them whatsoever, good, bad, or indifferent. And she is sorry to the Franks.
But today, Miss Pate, that's what I'm talking about. I get everything maybe before they got here today. But for God's sakes, there are parents here that are talking about what trauma has happened to their child at your client's hands. And she didn't even have to look at him. She could have told me, as people do, that she's sorry, but nothing.
But I am sorry, sir.
And Your Honor, I would like to reiterate, and not to speak out of turn, Ms. Slater is very nervous about being in front of Your Honor and in this court today. And I do reiterate that she is 76 years old and this is her first time coming to court, to my knowledge, for anything, but I know for a fact for something like this. She has expressed her remorse to me multiple times. I've had to remind her of the no contact order for that purpose. And I do understand what the court is saying and her not saying anything today. However, I can represent to the court that she has expressed remorse to me about this incident. And she has wished she could apologize privately, but for
Okay.
the no contact.
That's all fine and dandy. But how do they know that to say that to their little girl? They don't.
It's unfortunately one of those situations with our, our system, which of course there's a very much a need for no
This is
contact.
not, no, today, I get beforehand. But today, I gave her 2 opportunities. She doesn't have to even look at them. To just say she's sorry, and she didn't.
She did, Your Honor. Right. I just want to make sure the court heard. I'm sorry. She said it a little quiet.
Oh, I heard it. Too late. Is that said, because at this point, I don't know if that's said because she's really sorry and remorseful about what's happened to this little girl, or if she's only saying that because I pointed out that she didn't.
Your Honor, what I can say is before today, she's expressed remorse to me. And as Your Honor knows, I do represent a lot of clients, and quite candidly, there are a lot of clients who don't. And unfortunately, I don't have the opportunity to say that about them. But in Ms. Slater's case, I can say that. We've had several meetings outside of court as well, in person in my office, both to discuss this case. And quite candidly, since the beginning, Ms. Slater has both been apologetic, but also wanted to take accountability. I believe one of her words to me at our in-person meeting when we were reviewing the footage of the incident in my office was, I believe I deserve some sort of punishment, and I want to be sorry and move this behind me, and I know I can't reach out to the parents. And of course, at that time, I reiterated, no, absolutely not. Do not reach out to the parents. You're under the no contact order.
I have to give the Franks credit, because I think that had been my daughter, I would have lost my darn mind. I'm not even going to pretend I would do something different than that. But that's me. It's the sentence of the court. I'm going to place you on 18 months prosecuted deferred sentence, and I'm going to let you know that in my mind that I wasn't sure whether or not I was even going to allow the deferred. I looked at your lack of record and decided that I would indeed give that to you. But initially, my first thought was I wasn't going to give you the benefit of even being part of that program. But I will place you on that program for a period of 18 months. $455 fines and costs, $540 probation oversight fees. When can that be paid?
Your Honor, my client says she can pay $200 today and is asking for a payment plan as to the rest.
How much can she pay per month? Well, no, I'm going to make it $200. She's to pay by December 22nd, 2025, and then a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. I'm ordering no contact with Julie, Ryan, Natalie Franks directly or indirect. I'm ordering that there be no working with and or around any minor children. There is to be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will set a review hearing on this case that is to be held May 12th, 2027 at 9 a.m. With reference to jail time, ma'am, I have taken into account who you are and what I could see on this paper. I've taken into account the things that I've said on the record. And I've taken into account, as I did with the deferred sentence, the fact a lack of record for your entire life, at least as we see it here. But you can't grab someone's child. You just can't.
Understood.
So it's 90 days in Washtenaw County Jail. Defendant is to serve 15 days. The balance of that time will be suspended. Defendant is remanded.
Your Honor, I know Your Honor has issued a ruling, but can I make a request that her to be able to turn herself in a few days? Her husband does have some severe health issues, and I'm just asking, given.
I need medical regarding that, and I will consider it, but right now she's going.
That kick to the groin. The officer says it happened. The defendant says otherwise. These tiny seconds of video will decide whether this stays obstruction or becomes assault on an officer.